What is up, everybody? Welcome back to Truth and Transparency. Karen Reed hearing. It just actually ended. I got to see a little bit of it live. We're in for a treat. We're in for hella butt dials. It says butt dial gate. Grab your water. I don't know. Grab your sodas. Grab some popcorn. Grab some beverages. This is, I feel like somebody decided to give me a birthday gift. And they did it through the Karen Reed case, and they did it through this motion right here. Again, good afternoon from Morgan County, Indiana. Woo, woo. Love all my Midwest people. I'm a Midwest girl. We have the best work ethic. We have, they say the hottest looking human beings. And then they all moved to like LA to try to make it. But you guys, I like big butt dials and I cannot lie. But it's even bigger than butt dials. But let's get into it again. This is the Karen Reed case. This is Karen Reed's hearing from today. And this was about phone records. This is about discovery. This is about Rule 17 motions, meaning that, hey, judge, we need you to allow us to get these third-party phone records. All right, these third-party phone records that belong to Brian Albert, Brian Higgins, and who else did they want? They want another man. They want another man. But what's going to come out in this hearing is a lot of lies. I think it's kind of like fact that people lie to the grand jury. Police officers lying to the grand jury. The federal grand, well, actually, they spoke to both, Karen Reed's grand jury, and then they had to speak to the federal grand jury. But let's let the record speak for itself, right? So here we go. Again, this is just getting started. Come on in. Come on in. Make yourself feel at home.
Officer John, will you come up here? All rise for the court, please.
What's up, Boston?
Now, what we need seated.
Good afternoon, Your Honor. We are on the record on Commonwealth versus Karen Reed on docket 22 CR 117. Beginning with the ADA, can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your
Good
Honor.
afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DiStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion is allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from State Police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And
Yes.
okay,
This is
and
about
do
to
we
get good.
have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay, all right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton police officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that, Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the self-recusal of the Canton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right. It looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to
So
provide them as well.
they're two separately filed motions, right? And
Yes.
one of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except
But
for
that's three different people, or one different person on this.
one different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
This is about to get crazy.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials, which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred and continue to.
Okay, so right here, I'm going to say this, that I just believe that his argument, when he says that they've had a past resisting relationship, I think you're now making it relevant to actually look at these people's communication over the course of like 3 years prior to the murders, just to see how often they would text each other, would call each other, would anything happen in the middle of the night. Would there be like these quick 22-second phone calls, butt dials, or whatever? But now this argument, in my opinion, is, well, let's compare how much they talked via the phone, via the text, up until the murders, and then after the murders. Let's go ahead and compare some things. So I think his argument actually now is opening it up to be like, yeah, maybe we should compare how they talk to each other before the murders. So
to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard on the Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now.
dude, Lally just did not follow the court's order. She says, give this to these third parties. He just did whatever he wanted, which was he didn't do anything. And then claimed he just didn't give these motions to the lawyers of the third parties. So like they don't even know what's in these motions. And she ordered for that man to give them this prior to this day, and he just didn't do it. He literally disobeyed a court order.
Now, what do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So,
can I have one moment, Your Honor?
Yes.
There it is, Beverly saying he's not complying with her order. And I just think this goes to show that, again, this is another example of him dragging his feet in this proceeding, not the defense. You know, lally-gagging around, Lally. Here he comes.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure.
What you want to do, Bev?
I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as a court.
Okay, just so really quick, everybody's following along. This is to obtain these phone records. Okay, the federal investigation only did like an outline summary of some stuff. So that's why we're here today is, hey, we know this stuff exists. We know there's communications. We know that it took place on, January 29th. And then there was stuff that happened afterwards in, April, around the time of that federal investigation that led to a federal grand jury. And because of all of this, this is all relevant. We need to know, we need to have these records in admissible form to be able to be used at the trial. This little summary of like, yeah, this is here. They need this stuff to be official. No hearsay, no that, boom. These are the records. If we get this in discovery, then it is admissible evidence to use in the trial of Karen Reed. Okay. And this has to do with Brian Higgins, Kevin Albert, which is one of the Canton police officers, who is the brother of Brian Albert's, where the house is that this all went down at. Okay. and then Brian Alberts, his phone, and then something to do with the Chief Berkowitz, which I don't even know right now what's going on with him. But so everybody understands what this is. This is for the courts to deem these phone records relevant, admissible, and we need to get them in a form from the providers, meaning Verizon or T-Mobile. We need to get this from them, and this is like a third party subpoena. Like, boom, you have to turn this over.
Court is aware Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case. He has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Pasciuco on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's
for us.
Pasciuco.
P-A-S-C-I-U-C-C-O.
Good afternoon.
Hey, oh,
Thank you, Your Honor. Just a little bit of
compadre.
background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or a cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay.
Because
Thank you
Lally
very
didn't give it
much.
to you. Crazy.
All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion.
Here we go. This is
Mr. Lally, you
unbelievable.
didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order?
How is that funny?
Providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers.
Yes, Your Honor.
Okay.
He's admitting that he did not
So
comply with an order.
Council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Here we go.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover,
Okay, so January 29th, 2:22 in the morning. That is going to be just like 3 hours, 3.5 hours before they find, John O'Keefe's body. So that is the night in questioning here. So January 29th at 2:22 a.m.
that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there have been so many butt dials, to be frank.
I've never seen a case with so many butt dials. So he is claiming that this is from a butt dial. Okay, when confronted, then the federal prosecutor says, "All right, well, I'm going to show you your phone records." And right here it says that you made a phone call. You also received a phone call. Oh, that must have been a butt dial. That had to be something but I like big butts and I cannot lie. What? Wait, it gets better.
Frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted.
Right there, Yannetti giving a description of the fact that the butt and the phone couldn't have possibly met in some type of manner, as the phone is on the bedside table and his butt is in the bed. So how those two would have met, unless he, I guess you could say, was, I don't know, having some reminiscence of, I don't know, war, and he's throwing himself all over the place and just butts it all the way up on the table, and it. But that, to me, with him showing that demonstration, like your phone's here, your butt is here. Those two could have never met. Yannetti, cracking me.
Admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching.
Oh my gosh. So now, so Brian Higgins says it had to be a butt dial. Now we're on to Brian Albert. And Brian Albert's first thing was it had to be a butt dial. It had to be a butt dial. So here we go. But let's hear what Brian Albert's testified to the grand jury.
Watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed.
You guys! Wait. So he changes his testimony. So Brian Albert testifies and says, okay, yes, I was in bed with my wife and we were engaging in an intimate situation and my phone was in bed with me during this intimate, and that I'm sorry. This is what people were testifying to these grand juries. After, of course, being caught in lies.
So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins. But again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian
Higgins didn't hear any intimate sounds. God. Oh, God. These people are going to be testifying in this trial, in this murder trial. Oh, boy.
Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January
for Brian
29th.
Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th.
Fourth.
That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute, then another call with Albert for 10 minutes, then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
That's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third party counsel if they want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, well, with respect to our general arguments, we'll just rest on what I'll rest on what I said previously. And we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert. All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right. We're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pre-trial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is
No,
what the,
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
all right, and you can't be here next week.
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is if you're not here and you have to
well,
be here
that's
for
why we
that.
did.
So
That's why we did that, so.
Ms. Yannetti I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday,
Sure.
where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Thank you, Your Honor.
Thank you.
March 26, 9 a.m. hearing on all pretrial non-evidentiary motions.
All right.
All right, so there you have it. There is going to be another hearing, and that is next Tuesday. We'll be covering that. I just have a question. Who is the target of the federal investigation? If it's not Brian Albert, and it's not Brian Higgins, and it's not anybody of Brian Albert's family, meaning like his wife, his son, Brian Albert Jr., and then his daughter Caitlin. And then Higgins isn't. Who is there left? Who is there left? Well, let's see. You got Colin Albert. He's left. And you got the McCabe's. Has anyone come out and said that they're not, but that's something that I caught and wanted to listen to is when they said, wow, okay, so I've received permission to say this. And I thought, ooh, interesting. Okay. So who do we think is who's the target of this federal investigation? But how about this? Why y'all lying? Y'all made phone calls. You act like you didn't. You act like there's butt dials, and you get caught in the lies, and you're lying to grand juries. And remember, the grand juries who indicted to have this even go forward, okay, with the Karen Reed case in itself. So who is being investigated? And then also, I would think the target of the investigation, in terms of and if you helped somebody cover up what you did to John O'Keefe, how could you not be the target of it? Or are they just using that as a technicality by saying not the target? But yeah, you are involved, but you're not the target of our investigation. Our target is, like, how can Jen McCabe not be the target of an investigation where she's asking how long to die in cold? And that's how the man is found, and that's hours before. That to me is like, okay, well, is she the target of the investigation? Because do we really think that Jen McCabe beat the crap out of him? I mean, I don't. But I believe that she 100% forced upon a narrative to frame Karen Reed. But if the investigation, so why did they ever come in the first place? Who's the target of this? But notice how nobody said that there is no investigation. There is no target. So there has to be a target, but who is this target? And that's interesting. That's interesting to me. I'm lying, but why am I lying? Like, how you'd ask me that. Okay, so why are you lying? Why did you lie about what you did? Oh, you didn't want to say that you were doing X, Y, and Z, like in bed with your wife? Like, no. You said you all went to bed. You guys weren't up. You guys went to bed. So that's interesting to me. This is all interesting to me, that conspiracy itself holds its own. It's its own crime. It has its own count. You could be found, not guilty of X, Y, and Z, but conspiracy, whether or not something happens or not because of it, you can still be charged with that's a crime. Conspiring to do something, whether or not you go forward with it, is in itself its own count. So I don't know. I think it's interesting when they say that they're not the target of, like, I have permission to say that my client isn't the target of this criminal investigation, of the federal investigation. Okay, well, maybe then who is? Who is? Why did this ever even happen? Somebody's the target. Something is the target. Something led to all of this. So it's just interesting. But they're back in the courtroom next Tuesday. Certain people said they can't be there, so I'm curious if then is Alan Jackson going to just be the one doing it next Tuesday? But a lot of motions were filed. But there's the big one: is the motion to dismiss, and I think that's going to be heard then on Tuesday, if I'm not mistaken. So again, butt dialing when your phone's not in your bed, answering butt dials. So everybody's butts are answering and calling that night. I mean, come on. What is a jury when the jury hears this? I mean, anybody that's going to be on the jury is a juror in this. You hear that stuff, like you're not just like, oh, you're like, oh God, that makes so much sense. Yeah, I could totally see that happening. Usually when you make a butt dial, let's be honest, and you make a call that you shouldn't, it goes to like the randomest people. Okay. You're like, I haven't talked to that person in forever. And your phone called, because it got into like your contacts and it got into some random ass person. And then you see like, oh my God, my phone called, somebody that you don't talk to anymore, that like, that's like, those are the butt dials. But everybody's saying that everybody's phones are being answered by butts and called by butts. Come on now. That's the same thing that Jennifer McCabe, she must have made a butt dial. Because remember the night of with John O'Keefe making a call to him, that must have been a butt dial. And I think Yannetti pretty much sums it up. But I've never heard of a case that has more butt dials than this case, than any case out there. So, yeah. So that's, I want to know who. Yeah, it is strange. Who's the target of this federal investigation? So. All right, guys, but Jen's butt is very smart. That her butt can do Google. I think she only said that there was that butt dial was to John O'Keefe, like at a certain time, right after midnight. But you guys, if Karen Reed did not obviously run down and put her boyfriend in the snow and leave and all that crap, then this is a cover up. Then this, you're framing Karen Reed. You're sprinkling her tail light there. You're doing all this stuff. So you're covering up. You're involved in a conspiracy to cover up for who, for what? That would be a person. So who did everybody cover for? They covered for a person, in my opinion, and they're covering for the truth of what happened inside that home that night. And Kevin's text to this Brian Higgins, because Brian Higgins completely ghosted Brian Albert. And so Brian Albert's, getting all worried. And why didn't Brian Higgins get why wasn't he subpoenaed for the, they all thought that Brian Higgins rolled. They all thought that Brian Higgins turned state's evidence against them. Okay. So that's kind of what like the text messages look like. That's what he says. Lally's saying that this is just basically that their facts are wrong. This is hyperbole. This is hyperbole. This is pure conjecture, pure speculation. And it's just like, dude, it's not. These people are all saying they're in bed. They went to sleep and they're all talking. And then this Berkowitz, why is he talking to everybody that next day? And then the day that he miraculously is driving by, he happens to find more taillight in a moving vehicle on the lawn. And he's not even supposed to be investigating this case anymore. Because they were conflicted out right away. So, and I would think it would be relevant maybe if you want to talk about I'd want to know who was all talking to each other on the 28th. I would have left that alone. Because the 28th was that night going into then the 29th. But I think it's also relevant to look at people's phone records and to see how often they talked to prior to, that incident. Do you normally talk to this person? Well, let's look at phone records prior to, and you never talked to them on the phone. You never texted with them. Now all of a sudden you are, so I don't know. But I think that Karen is 100% based on the evidence, based on the digital evidence. She's 100% innocent. I mean, I think that she was drinking and driving, obviously. I think that they were all drinking and driving. I think that the McCabe's were. I think that anybody that left the waterfall, I think that they were all drunk. So, but she's 100% innocent of harming John O'Keefe in any way. And that the evidence, the digital evidence shows that these people covered up whatever happened to John O'Keefe, they covered it up to put him in the cold. And they had a chance, an opportunity to save that man's life, and they didn't. So the question is if this moves forward and there's actually a trial, then all of this stuff comes out in a trial. If this doesn't move forward and this gets dismissed, okay, then none of this comes out. So if I'm like someone like a Jennifer McCabe, I don't want this to go to trial. I want these charges to be dismissed against Karen Read, right? Because then I don't have to testify. I don't have to commit perjury. Okay. So think about that. I believe that someone like Jen McCabe does not want this to go to trial. I wouldn't want this to go to trial. I don't want to testify. If they have me and I said something to the grand jury, and then now I know that, I don't want to put myself in a situation to be arrested at all, right? And perjury is how you can get me, right? That's a crime. And each time you lie, it's technically a separate, offense. So I don't know. If I was just these people, I would not want this going forward. I would want the motion to be highly regarded by the judge, by Bev, and I would hope that she dismisses this and then we have to ask ourselves, who would then, you need the prosecution to come forward to file, to eventually either refile charges against Karen Read, or you are filing charges against somebody else for this, and go look at the stats on how often that ever happens, but more of the truth comes out if there's a trial, like a lot of things. But I wouldn't want to be put in that situation if I was any of those people and having to testify. So if they have all this pull or they can do whatever, why aren't they just telling Bev to dismiss the charges? So it's interesting to me. This is all interesting. All interesting. But Dow Bonanza. Yeah. Uh-huh. And then you're going to have people testifying, though, to we're not even talking about John O'Keefe's phone and all the movement that it does, after the fact. Who had his phone? They're running around with it. They're passing it off to people. Again, this is all that's where it comes premeditated. You know what I'm saying? Like, this isn't an accident. If it's an accident, call up, you're saying Brian Higgins is EMT. Well, then why didn't any of you guys try to save this man's life? Okay. What it looks like is it's premeditated after the fact to cover it all up. And I don't know what you would charge these people with, but so maybe they don't mean the target of the investigation, but they're just part of the investigation because, I don't know. These lawyers are saying my client did not conspire with anybody for any reason. Okay, well, what are they going to come out here and say? My client conspired? Come on. And people say, I think it's Proctor. But so nobody's investigating. If the federal investigation is targeted towards this man, and so they brought him in to cover for what, though? What? Do you think that Proctor is going to be telling the truth? Do you think that Proctor's not going to cut some deals because he didn't kill anybody? Did he? What do you think Proctor's going to say? Man, I felt some pressure. This took a wild turn, and it went, no, like, you kept on doing X, Y, and Z, like, you kept on going. So that's interesting to me. It'd be one thing not to maybe arrest Colin Albert, but to just flat out do all of this, that's woo. If you maybe just wanted to bury who, once you're framing somebody, like, I think that you deserve to spend the rest of your natural born life behind bars, framing somebody to take away the rest of their freedom. Yeah, no, you're going to prison forever in my mind. I don't know. So, but I'm just saying, do you think that Proctor's sitting there like, dude, I'll cut every deal possible. I'll tell you everything you want to know. I'll tell you everything. And I'm not doing a damn, I think this is what Turtle Boy was talking about, is which one of these people are going to, make the move first. and say what they know. So I think it's getting closer that time. Butts are puckering, but is Proctor just going to go down and keep his mouth shut? I don't know. But we'll be back next Tuesday. So less than a week from today, they're back in the courtroom, and motion to dismiss coming. Talk to you guys then. Adios. Peace. Peace.